Everyone, welcome to our Chicago's Best Ideas lunch on the ideas of Richard Posner. Now, for those that graduated before this tradition started, one of my predecessors as dean, Saul Lovemore, started a tradition called the CBI lunches, where once a quarter, a faculty member presents one of Chicago's best ideas that's meant to be one of the great ideas of a Chicago faculty member from the past that we think is important to expose our students to. So, for instance, this is one of the 50 times a year that we expose people to the Coast Theorem. Normally, though, it's one faculty member presenting one idea of a great idea from the past. Today, we're doing something a little bit different. Today, it's Richard Posner Day at the law school, where we're installing the first ever Richard Posner Professor of Law. And we decided to have 4 faculty members, all 4 of whom clerks for Richard Posner, to each present one of Dick's ideas, because obviously he has 4 times as many as everyone else, and so that's appropriate. So today we're going to have, in order, first Randy Picker is going to be talking about one of Dick's ideas. Randy clerked for Dick from 1985 to 1986, followed by Jonathan Masur, who clerked for Dick from 2004 to 2005. Then Jennifer No, who clerked for Dick from 2008 to 2009. And then finally Jacob Goldin, who clerked for Dick from 2004 to 2009. All right, so we're going in both the order of ideas chronologically and the order of clerkship, both of through. So, Randy, kick off.
Thank you so much. I'm going to do this. Wow, what a great day. I saw my co-clerk, Greg Larson, he's here somewhere. I saw Sam Peltzman. I took my first economics class in the college from Sam Peltzman. So I can't believe how excited it is to be here. And I want to say right up front, I am completely sure that I would not be standing here today right now if I had not worked for the college. That's just a gift. Just a gift. It transformed the arc I was on. And so I won't say more about that, but it's absolutely true. So I am going to start at the beginning. My job in this talk is to get Dick Posner to Chicago. That's what I'm going to do. So if you go onto the website, the official bio is still there. It talks about his time at Harvard Law School, has a little law review, clerks for Brennan, Jeff Stone did the same, though he obviously went to Chicago, FTC, a Solicitor General, Task Force on Communications Policy, Stanford for a year and comes to Chicago. And I want to play through that. That's what I want to try and do here quickly. We'll start as a clerk. Everything suggests that Brennan's clerks were active in helping with the opinions. Maybe that means they wrote the opinions. I wasn't there, I don't know. But one of the cases that looms large, I teach antitrust, is the Philadelphia National Bank case. Involves some mergers involving banks. The case announces something known in the antitrust trade as the structural presumption. This case goes back to 1963. Yet the most recent merger guidelines from the FTC and the DOJ, I don't want to say they rehabilitate the structural presumption, but they really run out of heart. And so here's a formulation. Dick's a year out of law school. And here we sit today, and it is a core part of how U.S. merger policy works. All right, that's Philadelphia National Bank. Now I'm going to go to Bonsworth. So Dick goes eventually to the Solicitor General's office. He argues a number of cases in the Supreme Court. I'm going to focus on 2 antitrust cases. Bonds involve grocery mergers in Los Angeles. I teach the facts of this case. It's a fantastic case to do some HHI calculations. Presumably everyone feels the need to do that occasionally, right? Herfindahl-Hirschman index, square some numbers, add them up, see what's happening to market shares. Dick argues this case and wins. And Bonds is still out there, though we'll say a little bit more about that in just a second. And then he argues and wins the Schwinn case. And the Schwinn case is about vertical restraints. And that area has bounced around, and now with the Legion case in 2007, that area has changed. But here are 3 critical antitrust cases in the 1960s, Philadelphia National Bank, bonds, and Schwinn, that Dick has his hands all over. Now, he would later say in an interview in 1992 that he changed his mind about bonds. That he believed it when he argued it. It wasn't that he merely represented the government and did what he was supposed to do. That's a fine thing for a lawyer to do. He thought the government was right, and he changed his mind over time. And the thing that I maybe took away most from clerking for Dick, he listened to us in chambers. I did not understand why he listened to us. We were smart, sure, but we were young, and what did we know? But it was crystal clear that Dick thought he could learn ideas from anyone. And he was constantly open to that possibility. And occasionally Greg and I delivered, I think, on that. But I walked away with that sense that you have to be focused on each moment as sort of a learning moment and not be certain where that's going to come from. Really, really impressed me. So the idea that he changed his mind on this, that doesn't surprise me at all. Bonds is not highly regarded at this point. But it's the evolution that I want to focus on. All right. Where do I want to go? Well, I want to go obviously to, communications policy in 1967. What could be more exciting than that? Well, I suspect you say lots of things. I teach regulated industries, network industries as we now think of it. I think it's super exciting. So I'm not going to be defensive about this. But he is the general counsel for this operation. Everything suggests that he was an incredibly quick typist. He produced drafts like you can't imagine. Everything suggests he was the one who drafted this document. There were lots of people involved, one of whom will pop up here in just a second was a consultant, William Baxter. Baxter was at Stanford, would eventually go to the Department of Justice as head of the Antitrust Division, but we'll get there when we get there. Now, how did the report do? Well, the Johnson administration issues it towards the end, and the Nixon administration disavows it immediately. So, and this is the nature of this kind of thing. There are turnovers in Washington. I think, it was good preparation for being a scholar, right? Most of us write things that take a long time to matter, right? And so you need to have faith in the process. Runs hard in economics. This is the biography of Dick, which if you don't have, well, shame on you. Shame on you. It's really terrific reading. Posner and Coase at that point. One of the things I'm going to track here is where does Chicago come from for him? That's what I want to do here in the talk. But at the same time, he writes a memo in the midst of this, saying maybe we should break up AT&T. There's no pending antitrust case, so who knows when that might happen. The memo, and this is in a world in which how did stuff get anywhere, is apparently in AT&T's hands in 24 hours. Right? Mechanically, how did that happen? I don't understand. AT&T called Lyndon Johnson, right? And so this memo, which I would, kill to see I shouldn't, but I would love to see the memo, right? As you know, AT&T is the last major breakup in antitrust. 1982, Baxter was there, connections between Baxter and Posner, maybe. Okay, Dick publishes his first two law review articles as a Stanford law professor in 1969. The one on the last, natural monopoly regulation, the other one on antitrust, two of them Stanford law review 1969. If you want to trace the intellectual roots, we want to look at the star footnotes there. Baxter, director, the legendary Chicago name. He's gone out to Stanford, he's at Stanford Law School right now. Johnson and Ross had both been involved in the telecommunications project, and Baxter was Stanford's antitrust person. All right, so we start to see some Chicago roots there. That's the first piece. The second piece, okay, he says, everything I have here, I got out of talking to Aaron Director, right? There is a long history of that back in that era at the University of Chicago Law School. So even as Dick is not in Chicago, he's talking to Chicago people at Stanford. George Stigler is spending winters in Stanford. George understood weather. And so he's hanging out with George Stigler out there as well, and he gives a paper at the I.O. workshop at the University of Chicago. I suspect Sam can tell us about that workshop. We won't make him do that. But the long-running workshop tradition, Dick gives this paper there. All right. This paper, and that's what I want to focus on, and I've got, a minute and 15 seconds, is 96 pages. So I think we think sometimes that law review articles used to be short. They did not. Oh my God. And 5 pages in, he does this. Dick thinks that this article is synthetic and not original. I don't know. I teach the natural monopoly class, as it were. When I started to teach this class, that was the first thing I read. Right? It's really, it's got a bunch of super interesting ideas in it. It's widely read. It is turned into, 30 years later, this book, right? The article is sufficiently successful. The reality of law review articles is most of them don't last 30 years. Dick's last a long time. I want to finish with a quick analysis of a hero's journey. And everything I know about hero's journeys I get from the Marvel Cinematic Universe, the MCU as we think of it. I have Thor Ragnarok in mind, which, as you know, what happens at the end. There's sort of epic planetary destruction. There's a lot of that in the Marvel Universe. Fortunately, a universe, lots of planets to work with. And at the very end, they have this question. Is Asgard a people or a place? Okay. Well, Dick Posner found his Chicago people before he got here, right? So when we think about who is Chicago, some people come to Chicago and stay. That's me. Some people come to Chicago and leave. I stare at my friend Larry Lessig. Right? Still Chicago, right? Chicago is a people. Chicago is also a place, right? Dick comes here having learned from Chicago at a distance and helps build the Chicago that we know today. Thank you.
Want to use my clicker or do you want to use the other one?
Yes, absolutely. Thank you.
Okay, so there are at minimum 2 very substantial perils when trying to talk about Dick Posner's best ideas. One is that there are a lot of great ideas out there and it's pretty hard to choose one. I think that his work in intellectual property, his work with co-authors and others that I will describe, is some of the most important work that he did, and also by far the most important work that anyone did in intellectual property, and yet I don't think it gets a lot of shine. I think that people think about him much more in terms of other forms of property or contract law, torts, antitrust, tax and administrative law, a variety of other fields. So I really wanted to talk about something in intellectual property, and I selected trademark law. The other peril is that a lot of what I'm going to say is the same thing that your professors say to you on the first day of class. So if there are any trademark students in the room here and you find yourself thinking like, oh, well, that's what Omri told us, on Monday of the first week, I'm here to tell you the reason why people are saying it to you on the first day is because it's one of Posner's best ideas, and he put it into the canon 40 years ago. Okay, so here's what trademark law looked like before law and economics came along. So this is from a 1896 treatise. A trademark is simply a device to indicate the origin of goods, and the right to its use is founded on the principle that no man has a right to sell his goods as those of another. So it's a very sort of moral rights type of theory of trademark law. People deserve trademarks because they have a right to control who believes the goods are coming from them and whose name it is that the goods are being marketed under. Okay, so enter Posner and co-author. The co-author is Bill Landis, also a longtime member of this. Faculty. The cat is Dinah. The cat is not the co-author, although maybe the cat is the inspiration for the co-authorship. So that's Bill Landis. I'm just calling him co-author here because this is Richard Posner Day. Although if there are any former Landis students or RAs in the audience who would like to create a Landis chair in law and economics, the dean is right over there. We'd be happy to speak with you. In true Chicago fashion, these crucial ideas came not just from Posner, no man is an island, and he wasn't either, but from his collaborations with others. He and Bill Landis wrote a series of articles, eventually leading to a treatise and then a big chapter in his economic analysis of law book that revolutionized the field of intellectual property. Other foundational work was being done basically at the same time in the mid-'80s by Judge Frank Easterbrook, who was writing a series of opinions on the Seventh Circuit that Dick was drawing from, and Dick was writing his own opinions at the same time as well. There are some areas where Dick did the academic work first, and then it showed up in his judicial opinions. Trademark law is a place where I think he really did the judicial work first, and you see him, I'm going to show you bits and pieces of a 1985 opinion later on. You see him sort of trying to work through his conception of trademark law, building in part on some other opinions that Judge Easterbrook wrote, and then that gets put into a series of articles in these books written later on in the mid to late 80s. Okay, so what are the big insights? So Posner and Landis and others wanted to understand trademark law in economic terms. And what they wanted to demonstrate was that there were significant economic benefits and costs to trademark law. So the benefits, number one, provide trademark owners with an incentive to invest in quality, in the quality of their goods or the services that they were providing. That's not so far from the sort of moral rights conception that people were talking about before, but Dick formalized it in economic terms. This way, if everything is going to have your trademark attached to it and you can control the use of that trademark, that creates an incentive for you to garner a reputation for quality and to preserve that reputation. But more importantly, Dick wanted to understand trademarks as a way of reducing consumer search costs. The point of a trademark is for us to be able to find the product or the service that we want to purchase based on our prior experiences with that product. And the trademark is the way for us to go about doing that. On the other hand, there are significant costs. One of them is cost of rent seeking or squatting. We worry about people spending a lot of money trying to acquire a trademark in a way that's not very productive. The trademark is basically a little grant of property from the government, and if the government is handing out free little pieces of property, then maybe it's a good reason to try to spend a lot of money and acquire it. And then secondly, harm to competition. If somebody got a trademark that could allow them to prevent other people from using a word, a phrase, a picture, a feature of a product that is necessary for them to compete, then that could be a real problem. And that could diminish competition rather than facilitating competition by allowing the trademark owner to squeeze people out of the market. And Dick said we can understand basically the entire modern structure of trademark law, again, a modern structure that he and Frank Easterbrook were in the process of creating at that point. We can understand it all in terms of these economic principles. So first of all, the rules about acquisition, use in commerce. How exactly do you go about acquiring a trademark? So the rule in trademark law is not that you're the first person to register the trademark, not that you're the first person to use the word or to think of the pretty symbol or something like that. You have to be the first to use it in commerce. And so there are cases like this one. This was a website that somebody put up in sort of the early internet days called PETA, People Eating Tasty Animals, PETA.org. And you can imagine that people for the ethical treatment of animals didn't really love that website. And so there was a big trademark battle over it. And the trademark battle was resolved in favor of people for the ethical treatment of animals on the grounds that PETA.org was a trademark associated with their business. They were the first ones to have used it in their nonprofit business. And this cyber squatter who came along didn't get to grab it just because they had a clever idea and put it up on a website. Clever though it might be. Okay, so that's use in commerce. Another major issue in trademark law that Dick explained in these economic terms is the way that different words carry different competitive advantages or disadvantages, benefits or costs, depending on the type of the word. So some words are sort of, here, I'll show the next slide and this make it easier. Some words are distinctive by being arbitrary trademarks. Xerox started out, at least, as an arbitrary word. It didn't mean anything. It was just an invented series of letters by this company that they used to describe their photocopying machines. And there are multiple good things about using arbitrary words like that as trademarks. Number one, there is in theory at least an infinite supply of arbitrary words. You can always create new words by adding additional X's on the end of it, as the modern internet economy has shown us. Number two is that you're not really squeezing anyone else out of the market because they don't need to be able to use the word Xerox, which you have just invented, to describe their own photocopier. They can use other English words to describe it. So, no diminution in the stock of language available, and no significant harm to competition because competitors can still explain what their product is and what they're meant to do with it. There is, of course, a danger. Some of you are probably thinking like, wait a minute, Xerox is not the generic word for those photocopying machines. There is that doctrine exists in trademark law as well. It's called genericide, when something dies as a trademark by virtue of having become generic. And so if you're Xerox, one thing you have to do, you can't be the victim of your own success. You have to fight very hard to maintain the validity of your trademark. That's as contrasted with light beer. Miller Lite wanted to trademark the word light, L-I-T-E. And the court said, that's too descriptive. You're describing the type of beer, and other people who want to sell beer of that sort might want to use that word as well. So here you are not creating a new word. You're taking a sort of bastardized word out of the existing language, but you're doing it in such a way where you're going to inhibit competition among others. And then there's a third category, that's American Airlines. Sometimes, under some circumstances, you can take even a descriptive word, and as long as you can show that it's become fully associated with your brand, and that when people see American Airlines, they think a particular airline and not the category of airlines operated in America generally, that can be good enough to secure a trademark. So this whole structure of sort of different types of trademarks, descriptive words, generic words, arbitrary or fanciful words, all of that is prefigured in the work that Dick and others were doing in the mid-'80s. Okay, last category, the functionality doctrine. So the functionality doctrine is very similar, the idea behind it is very similar to what I said about trademark word marks as well, in that the goal here is to allow people to trademark basically symbols and pictures that are in some way ornamental and not essential to the functioning of their product. Because if it's essential to the functioning, and you give someone a property right over it, now they control that, they can push everyone else out of the market. That's harm to competition. We do have a system of law that allows people to gain property rights over functional elements of invention. That system of law is called patent law. But trademarks are not supposed to be used for that purpose. And very importantly, patent law lasts for 20, patents last for 20 years, trademarks last indefinitely. So giving someone indefinite control over an invention would be a real problem there. One of the great joys in teaching or talking about trademark law is that you get to put up pretty pictures of trademark symbols that people use, you know, the Nike swoosh, the Coke can, and so forth and so on. Trademark law professors love that kind of thing. I'm about to show you probably the ugliest trademark-related picture, the least interesting, the grainiest and worst trademark-related picture regarding the least sexy trademark invention in the history of trademark. It's from this Posner opinion, Rogers v. Keene, 1985, 7th Circuit, which is maybe one of the most important non-Easterbrook trademarks ever written. So this case was about plastic office trays. That is the famous Rogers tray. And what made the Rogers tray so famous, and what made it notable, was that unlike many office trays, it had hexagonal, these side panels are hexagonal. It goes out and back in, and then long, and out and back in, and long. That's 6 sides. Your standard office tray looks like that. Those are rectangular. Nobody wants rectangular sides. And so Rogers claimed that they had a trademark in their hexagonal sided office trays. And the challenging piece of this was this isn't really functional in the sense of making the product operate better. Like these rectangular ones operate just fine for their purpose. The issue is that one version of functionality is that it can make the product look more beautiful. And Posner points out in his opinion, there's a real tension here because people aren't going to choose trademarks that are ugly. You know, if the Nike swoosh were ugly, nobody would want to use it on Nike. So there will be a natural tendency towards attractive looking trademarks. And we don't want to stop that. But on the other hand, if somebody is just creating ornamental features that look beautiful and using them because they look beautiful, Now, if you give someone a trademark on that, you're preventing other people from making nice looking products as well. And that really could be a harm to competition. And there is, again, another body of law that's meant to govern those things. Design patents. Design patents last for 14 years. Trademarks last forever. So the thing that Posner had to figure out in this case is how exactly you explain to a jury how to decide whether an element is really functional in the sense that it's being made beautiful, or whether it's just sort of ornamental and like beauty for its own sake. And so I just want to show you a couple snippets of the opinion because I think that this opinion is also just a really sort of remarkable example, wonderful canonical example of Posner opinion writing here from the mid-'80s. So here he is talking about the value of trademarks. One function of an automobile is to be visually impressive, opulent, magnificent, in a word, beautiful, and that the little statue of Mercury, he's talking about the hood ornament, is not just an identifying symbol, but one of the details, one of the adornments. It is like the fluting in a Corinthian column. So this is Posner in a Seventh Circuit opinion. Not a lot of judges write that way, then or now. By the way, if you want to see these things, that was the Mercury hood ornament that was on Buicks from the 1930s. So in one breath, Posner is referencing Art Deco era Buicks from the 30s, and then those are the Corinthian columns. Those are from literally the 30s, like the 00. So two great moments of design. So I love the sort of the erudition, the bringing together knowledge across various eras of human development and design. And now here's Posner commenting on the district judge and the district judge's jury instructions. And this is the Posner who holds everyone around him to a very high standard and is not afraid to say it out loud if he thinks someone is not meeting the standard. And so he's talking about the district judge and the district judge's jury instructions here. But these faults of diction or level are easily remedied with a blue pencil, which, if the judge was too busy to wield, he could have asked Rogers, one of the parties to the case, to wield it. Chastising the district judge a little bit for not, doing his own editing here of the jury instructions. Those of us who've been in chambers or maybe in the same judicial circuit as Posner are familiar with this sort of thing. But he's such a nice guy, he sort of wants to take it back. And so he says, we do not for a moment suggest that the district judge disclaimed such a responsibility in this case. He didn't just grab the bad jury instruction from one of the parties, he wrote the jury instruction that he thought would be the most sensible in this case, because he thought it was correct, not just because it had been supplied. But he can't quite take it all back because he really does think the district judge did kind of mediocre job here. So he says, it's possible that if the plaintiff had proposed a correct jury instruction, the district judge would have gone on it. I don't really think so. So there's Posner the critic, Posner the aesthete, and Posner the critic, all in one opinion. And so what do we end up with at the end? We end up with the jury has to determine whether the feature is something that other producers of the product in question would have to have as part of the product in order to be able to compete effectively in the market. In other words, is it an essential element of competition because either it performs a useful role in the product or because it is beautiful, or is it merely an element of sort of artificial design or attachment that is used to signal the provenance of the good and thus could properly function as a trademark. I'll leave it as an exercise to the audience to determine which of those things you think the Rogers plastic office tray, which category you think the Rogers plastic office tray falls into. But anyway, this is the law that Posner and Easterbrook and others were creating in the Seventh Circuit in the mid-'80s. This is how people understand trademark law today. This is the law really of trademark law and of intellectual property more generally that has persevered over the succeeding 4 decades. Okay.
Great. Well, it is so wonderful to see so many colleagues and friends and previous clerks. As we already know, Dick's work, of course, was wide-ranging, so it was difficult to pick just one idea. But I thought I would pick, indeed, one of those ideas in the field of administrative law, and in doing so, get to talk a little bit about Dick's love of cats. So, as many of you know, we just saw this picture. Dick indeed loved cats. Here he is in the New Yorker 2001 piece. And what Jonathan didn't put up here was the heading that accompanied this picture, right? It says, Richard Posner says that he is like his cat Dinah, playful, but with a streak of cruelty. Now, the year that I clerked with Rebecca and my other co-clerk Nathan, it was a special year for many reasons. I didn't see Nathan. Right, okay. It was a special year for many reasons. Amongst them, our co-clerk had his first child and sent out, as proud parents do, a birth announcement. And to our surprise, a few weeks later, we got an email from Dick, also with a birth announcement of sorts. He says, look, Nathan and his wife are not the only, quote, proud new parents. The Posners are the proud new parents of Pixie Posner. Because at this time, Dinah had sadly passed away. And the Posners welcomed Pixie at the center of the photo here. So, feeling great nostalgia, I then promptly searched all my emails from Dick regarding his cats, and I found dozens, including his excitement over creating the Pixie calendar, which was Pixie in various poses for every month of the year. If anyone wants to see it, it is lovely. This search also turned up an email in 2014 after I wished Dick a happy birthday. He responded and he said, quote, "My law clerks gave me as a birthday present a book called How to Tell If Your Cat is Planning to Kill You." Okay, that was your here. Okay, wonderful. He says very valuable for any cat owner. So it would not be unreasonable with a cruel Dinah and a book about how his cats were planning to kill him to wonder if Dick had a little bit of a secret fear of cats that he also liked when he wrote the opinion in a case called Hochter versus USDA, which I'm going to use to explore the really tricky question of what is the difference between a so-called legislative rule that has to go through notice and comment and a non-legislative rule that doesn't. I'm teaching this right now. It is a judicial slog, as I will just discuss here. And in doing so, I'm going to just focus, really just as a springboard, on Dick's opinion in Hochter. And I'm going to bring us to the mid-1990s now in this kind of trajectory here. And I think, not surprisingly, that same year, he reflected a bit on his judicial opinion in administrative law to write an article in the Chicago Kent Law Review, also in 1996, called The Rise and Fall of Administrative Law. And I'll reflect a little bit on what I think he meant by that, the rise and the fall. All right, so a little bit of backdrop in talking about Hochter. Okay, first, Hochter deals with the 1966 Animal Welfare Act. Okay, and basically this act authorizes USDA to generate standards through rulemaking to govern, quote, the humane handling, care, treatment, and transportation of animals by dealers. In 1971, the USDA, through notice and comment, okay, for the non-administrative law aficionados in here, what is notice and comment? Well, basically it is an onerous process where an agency has to publish a proposed rule in the Federal Register, then take comments, often increasingly with this AI now in the millions, but thousands, hundreds of comments depending on the rule, and then is required to provide a concise statement of providing the basis of the rule in a final rule, response to comments. Okay, needless to say, this is a cumbersome, expensive process. Empirical evidence suggests that on average it can take up to 2 years or more on average. So pursuant to that process, the USDA issues this rule, and in the rule sets forth the following language. That indoor and outdoor housing facilities shall be structurally sound and shall be maintained in good repair to protect the animals from injury and to contain the animals. Okay, it is against this backdrop. Now, this is 1971. About 10 years later, in 1982, Patrick Hochter, surely the inspiration for Joe Exotic, otherwise known as the Tiger King today, wanted to raise big cats on his 25-acre farm just outside Terre Haute, Indiana. Okay, so think lions, tigers, as Dick tells us, ligers, which is apparently a cross between a male lion and a female tiger, not to be confused with tigans, a cross between a male tiger and a female lion. And Patrick Hochter is trying to comply with the rule that he has to provide a structurally sound structure for these big cats. So he asks the USDA inspector, he says, how tall do you think that perimeter fence should be? And the USDA inspector, who's also a veterinarian, says 6 feet. What? Yeah. And so Patrick Hochter builds these pens that enclose the ligers and a containment fence around the primary enclosures, and then dutifully builds the perimeter fence outside it that is 6 feet high. And now some of you are like, 6 feet, that's not enough. Now recall, this is the Animal Welfare Act, so it's not only to protect humans from animals, but to protect animals from humans. And indeed, some of the legislative history suggests, and the rulemaking was concerned with often protecting animals from other predators. Okay, and Posner observes in his opinion, one can't help but wonder how much danger there was posed by the Indiana fauna. Unfortunately now for Hochter, the following year, 1983, USDA issues this policy memorandum interpreting its structural soundness rule to say that all dangerous animals must be kept behind perimeter fences that are at least 8 feet high. Poor Hochter. Now he is subject to citations and enforcement actions, maybe even by the same USDA inspector, who knows, citing him for a fence that, alas, is only 6 feet high. Importantly for our purposes, USDA issues this interpretive rule without notice and comment. Okay, so the legal issue in this case is essentially, as I've suggested, whether this interpretive rule falls under the exception of the APA so as to not go through notice and comment. In trying to distinguish between the so-called legislative rules that have to go through notice and comment and these interpretive rules that do not, judges have called this a slog, and they have experimented with various tests with generating a lot of confusion. For example, 3 strands of the doctrine, they ask, well, look, is there a substantial impact on affected parties here? So in other words, the judge might look at the 8-foot direction with the interpretive rule and ask, how many owners are going to be affected by this? What are the costs potentially of having to now build the 8-foot fence and tear down your 6-foot fence? Sometimes they would also look at the intent of the agency. They would look at the face of these memos and ask, well, was the agency trying to do something? Perhaps it had, for example, directive language, like in the memo, saying this shall be a violation of the regulation, to suggest that it was legally binding in a way that made it a legislative rule. And then finally, they came up with a test that they're still trying to work with to ask, look, is this memorandum practically binding? That is to say, when the USDA inspectors go out, do they feel like they have to cite every fence that isn't 8 feet high, or rather, do they look at a number of other factors, right? Look at the containment fence, look at the enclosures, and this was the state of affairs, and continues to be the state of affairs in this area of the law. Faced with this question. Posner's approach to this case was characteristically pragmatic. Okay, in his words, he says the task is not to plumb the mysteries of legal theory, but rather to look at the purpose of the distinction in the APA, characteristic purposive interpretation. In his words, when agencies base rules on arbitrary choices, an unfortunate use of a term, because he didn't mean arbitrary and capricious in the APA sense, okay, but he just meant in the ordinary sense. When agencies base rules on arbitrary choices, they are legislating. And so these rules are legislative or substantive and require notice and comment rulemaking. A procedure, he observes, that is analogous to the procedure employed by legislatures in making statutes. The common sense Posnerian pragmatism here, right, of requiring notice and comment rulemaking for legislative rules, he says, is well illustrated by the facts of this case. So for Posner, arbitrary interpretation involves this choice amongst alternatives that was left open by the language of structural soundness in the rule, right? So the agency could have chosen, for example, instead of 8 feet, in Posner's words, he said they could have chosen to require the building of a moat around the animals. You could also have the fence be 12 feet. You could electrify the fence, for example. These are all alternatives that were available, okay? And in interpreting the rule, Posner characteristically looks at the institutional competence of the USDA and says, look, agencies bring a wealth of expertise, okay? But when they're doing that in the context of case-by-case enforcement actions and adjudication, that is not the same kind of expertise that's required when the agency is making the arbitrary choice to choose 8 feet. When they do so, they are operating more like legislatures and therefore should use procedures more akin to the kinds of procedures that legislatures use, right? Hearings, for example, to get comments, and often having Congress consider the input that it's received. And so Posner in this opinion says, look, just think about all the information and input that could have been gained by, quote, the thousands of animal dealers, some unknown fraction of which face the prospect of having to tear down their existing fences and build new higher ones at great cost. Okay, in other words, the agency had not used the legally required mechanism to appropriately weigh the benefits and costs of these 8-foot fences. And in this manner, his approach is consistent with this broader call in his academic writing that administrative law focus much more on the real consequences of the doctrines rather than formal categories. For example, he critiques the Supreme Court, calls out the ways, for example, that hard look review serves only to ossify rulemaking as opposed to considering the limited benefits and accuracy by continuing to scrutinize the agency decision. So in conclusion, he asks in The Rise and Fall of Administrative Law, one wonders whether the court has any clue as to the consequences of its administrative law decisions for society. Maybe it doesn't think that that is any of its business. And in doing so, the article observes the development in administrative law scholarship towards this empirical turn and puts the empirical results side by side with what the Supreme Court is doing and observes the deleterious effects for social welfare. So to close, reflecting on this question today of does the court have any clue, does it care, I think it's fair to say that Posner's question is still an important one, especially for a court that seems to have rejected many premises of Posnerian pragmatism. Needless to say, there's a formalist and textual turn. And as a result, many of its decisions, I think, don't really take into account a lot of great empirical work being done. So just a quick few examples. Its removal jurisprudence doesn't take into account the wealth of empirical evidence by scholars like Neil Devins and David Lewis, suggesting that actually on the ground, removal restrictions aren't the main determinant of whether a president controls agencies. right? Instead, it's a host of other factors, including norms, see the Federal Reserve, including the president's control over the chair, the president's control over the centralized review of rules. In addition to that, the court has not taken into account a wealth of empirical evidence about administrative capacity. For example, its decisions regarding the best interpretation of the statute now rarely consider the capacity of agencies to the resources necessary now to make those arguments and determinations amidst its decisions on the other side regarding staff firings and reductions in force. Finally, the court's continuing efforts to apply the major questions doctrine, I think, fail to take into account the uncertainty costs and the lack of predictability, right? The latest tariffs opinion, I mean, most of it is all the disagreements amongst many of the justices about what exactly the major questions doctrine is, when it applies, and what its scope is. So it seems appropriate to end with more lessons that we can learn, perhaps, from Dick's beloved cats, a very popular meme here. Continues to remind us today that judges ought to better understand the consequences of their decisions, and perhaps in doing so, make us all better off.
I'm not sure. It's a tough act to follow, but at least I'll have a pristine whiteboard. Okay, so I'll talk about a tax case. If you sort of looked at Dick Posner's scholarship, you wouldn't really think this is like a guy interested in tax, like one article only kind of about tax. A lot of judicial opinions, though, on it. And it's kind of similar to the theme we've been hearing, where it's like tax isn't really like a big part of his work, but then you like look at tax and like his work is a big part of tax. So like, more opinions and case books get cited, The ones I'll talk about I'll focus on has been cited more than, well over 100 times in both judicial writing and scholarship. So this Exacto Springs was a corporation that made springs, really precise ones, like stuff that you use in like an airbag or something. And this guy was the founder and CEO. He was also the majority shareholder, along with two co-founders. And he got paid a lot. He got paid about $1.3 million a year, which was like 8% of the company's sort of earnings. And it turns out there's an IRS provision. There's a tax code rule that says you can deduct, if you're a business, you can deduct the salary you pay to your employees, but it's got to be reasonable. And so the IRS comes in and says, actually, this was too big, and they deny the company's deduction for the salary to this guy, Mr. Hines. Okay, so just like background, like why do we care if compensation is reasonable? If you've got a company that's making a payment to somebody who's both an employee as well as a shareholder, then what you worry about is that they're actually disguising something as something else. And so if it's salary that's being paid, it's deductible to the business, and so they only pay. So the only tax that gets paid is the tax at the employee's rate. If it's a dividend, if it's really just sort of a return on the investment, it's not deductible to the corporation. It'll be taxed to the shareholder, and so it's going to be taxed at both the corporate and the shareholder rate. This sort of varies over time, but under the law at the time of this case, most parties would have been able to minimize their sort of joint tax obligations by calling something that was really a dividend as salary instead. Okay, so what's going on in this case? So the tax court looks at the IRS determination. They have a 7-factor test. Dick mentions that some other cases there's a 25-factor test. And so I won't go through all the factors, but these are basically things like, was the employee like well qualified? Was it like hard to find well qualified employees? Things like that. And so the tax court sort of like marches through each one of these, sort of carefully saying how they come out. And they all sort of like pretty much come out for the taxpayer. A couple are like neutral. And then the way that Dick puts it in the opinion is, despite sort of all of these factors coming out positive or neutral for the taxpayers, stunningly, the tax court, only says that 900,000 out of the 1.3 million was reasonable and disallows, a big chunk of the deduction. Okay, and so this case is like known, and what it's sort of cited for, at least in the academic literature, is really for this like being the critique. This is like the big idea part here, is like the critique of multi-factor tests, right? And so like, I think this first bullet is sort of one of the most convincing ones, is if you've got a test that depends on a bunch of different factors that could come out differently in different directions and point in different directions, right? You need some way to weigh the different factors when they do come out differently, and when the multi-factor test has no guidance about the relative importance of the factors, right? Then you're sort of left. It might not resolve the outcomes. Another thing that Dick notes in the opinion is somehow you get all these qualitative inputs, and then somehow you're left. You come out. The output of the formula is a number 900,000. So that's weird. There's a problem, like kind of an analog to the business judgment rules. How I would think of it is like it sort of sets judges up as overseeing the business decisions. They have to sort of look and see, was this person like overpaid, underpaid? Like probably courts are not so well qualified to do that. And then it's unpredictable, of course, right? We just don't know how it's going to come out to the parties. And then I think one of the biggest ones is that it doesn't relate to the purpose of the statute. It doesn't relate to these factors. If you sort of go through them, they're not really carefully related to each other. It's sort of just like a hodgepodge list, a collection of what judges have applied. And it doesn't really, they're not well connected to this goal of figuring out if a firm is actually disguising a dividend as salary. Okay, so what does he suggest instead? This idea of the independent investor test, where the idea is you look at the industry, you look at like the risk and the returns, and you figure out what a reasonable return would have been to an investor in that kind of industry. Here, you got experts, they say it would have been about like 13% would have been pretty good. And actually here, the return was 20%. So any sort of reasonable investor would have been happy with this. And so we can't complain that and that's even after the salary. There's still plenty of return left over. So we're not going to sort of like look into it. It's going to be a presumption that the compensation was reasonable here, which is like an interesting idea. And so it's very clearly a better connection to the statutory purpose. It's probably more predictable to the parties. If you're sort of generating good returns, you're probably not going to get in trouble with the IRS. But it's like not perfect. And I think like the biggest issue with it is you get whether it's reasonable or not kind of depends on how good or bad the return has been. So in good years, you have a return of 20, 25, 30%, and you're going to have lots of flexibility to disguise dividends as compensation. And what about in a bad year? You have like a negative return or something, or a bad sort of stretch of years. Then even very low salaries are going to look unreasonable under this test. And actually, what you end up with is that the salaries then sort of like track the investment returns in a way that tend to look. I'm looking at Adriana now on this, right? That tend to look more like equity, right? Like residual equity compensation, as opposed to what we would think of the more way that like employees would be compensated. Okay, so like I want to sort of step back and say like think a little bit about like what was the real problem with the tax court's multi-factor test, and maybe the real problem here was that the 7-factor test was being used articulated as a rule rather than as a standard. And this can maybe explain a lot of the criticism that Dick sort of flagged here. So again, just like as a rule, we think of like a deterministic mapping. So you like have some facts, and like from those facts, you can sort of put them into a formula and mechanically figure out what the legal conclusion should be. And for that to work, you need there to be like these pre-assigned strict rules that tell us sort of how much role each of these factors play and what to do when they come out differently. In contrast, if we think of this as really a standard, we just really we want to have a flexible assessment of a legal question based on whatever facts turn out to be relevant in this case. How do we weight the different considerations? Well, it's just going to depend on the fact at hand, right? If these facts are relevant in this case, if they're really convincing way to answer the question, they'll be weighted higher here, and maybe less high somewhere else. So the weighting sort of emerges naturally from the setting at hand. But what do you need to do this? You need to have like a clear articulation of what the purpose of the statute is, and then you need to have like very, a cohesive way of going from from the facts at hand to saying how they address whether that purpose was met in this case or not. And so like from that vantage point, you can see that as being like the really useful parts of this decision, is saying, here's the goal of what reasonable compensation means. It's about figuring out if there's a disguised dividend, and then here's sort of an illustration of how we can like look at the facts in this case and learn if there really was one here. And so last thing I'll say here is that once you take that sort of broader view, then the problem really is not so much about having too many factors, right? The problem is having too many factors in the context of a rule. But it's fine once you sort of have a standard to say all these things could potentially be relevant. So you've got the stuff that like Dick focuses on, like the fact that there were independent shareholders who approved it. You can also look to see case by case were there benefits from mischaracterizing the transactions. Did the people who were getting it, were they shareholders or employees? And then it also opens the door to other factors that courts have not looked at as much, which is like, if it really was a hidden dividend, you would expect there to be some other payment to these other shareholders who weren't benefiting from the compensation. And so all these sort of other factors, it's a lot of factors that are potentially relevant, but there's no real problem from the perspective of the criteria Dick laid out once you sort of think of it in the context of the standard. Okay, so just to conclude, right, I think the thing to appreciate about this opinion is not so much just sort of the surface level that there's a bunch of factors, but really the thing to appreciate about it is the value of like how much work you could do by setting out a clear purpose of a statute and then illustrating how the different facts that could arise in cases can help be probative as to whether that question was actually how it comes out of the case at hand. Thanks.